And coming in session momentarily, we'll take you inside the Hart Senate Office Building for the afternoon session, day number 2 of the John Roberts hearings. Nominee to be Chief Justice of the United States, Senator John Kyle, there on your screen of Arizona. He'll be first up for this afternoon in a series of half-hour questions. So far, 6 of the 18 senators on the committee have asked their questions. The order of questioning this afternoon will go like this: Senator Kyle, as we mentioned, then Senator Herb Kohl of Wisconsin, and Senator Mike DeWine of Ohio after that.
We will resume the confirmation hearing. I've been asked to delay by 2 minutes the starting time so the electronic media can make appropriate introductions. And then I've also been told that my watch is a minute fast, so we're going to correct all those miscues. For 30 minutes, Senator Kyle.
Thank you, Mr. Chairman. There are several preliminary things I'd like to do and then get into a couple of questions that I wanted to ask you, Judge. First, to my colleagues, with reference to some questions that attack policy positions of the Reagan administration when you were working there as a lawyer, Judge Roberts, I tend to agree with you that it wouldn't be appropriate in your role as a current judge, not to mention your service on the Supreme Court, to be put in the position of defending policy positions of a previous administration. But to the extent my colleagues would like to engage in that debate, probably not in this forum, I'd be happy to accommodate them in that matter. Judge, as to your role, I appreciate, frankly, your candor and the clarity of what you have said. And you've said a great deal here. Obviously, you've drawn the line at issues that may come before the court. But I think you have already added to what we already knew about your approach to judging. That's the key question here, and I appreciate what you have added to that. And I'll get into a little bit more of that in a moment. There are a couple of other items that I would like to clarify. Our colleague Senator Biden had engaged you in a colloquy regarding some testimony given by Justice Ginsburg, and he suggested that Justice Ginsburg was asked about a specific case called Moore versus City of Cleveland, and that even though she had not written about that case, she volunteered to speak about it. Now, I think appropriately, you're not going to be a judge or umpire in this case as to whether she did or did not exceed the rule that she set down. That would be highly inappropriate. But I'd like to correct the record because that isn't what transpired. I won't read the entire transcript here, but would ask that the relevant portions be inserted in the record at the conclusion of my remarks. But just to set the background of it, she is testifying here in response to questions by Senator Hatch, and she said, "I have said to this committee that the finest expression of that idea of individual autonomy and personhood and of the obligation of the state to leave people alone and to make basic decisions about their personal life. Justice Harlan's dissenting opinion in Poe versus Ullman. Senator Hatch said, right. And then Judge Ginsburg said, after Poe versus Ullman, I think the most eloquent statement of it, recognizing that it has difficulties, and it certainly does, is by Justice Powell in Moore versus City of East Cleveland, the case concerning the grandmother who wanted to live with her grandson. Those two cases, more than any others, Poe versus Ullman, which was the forerunner of Griswold case, and Moore versus City of East Cleveland, explain the concept far better than I can. And then there are other things that occur in the transcript. My point here is to note that she was not asked a specific question about this case. She volunteered it as one of two cases that had interesting language that expressed what she wanted to express with regard to the principle of individual autonomy and personhood. And then further down in the transcript, she said, Senator Hatch, I agree with the Moore versus City of East Cleveland statement of Justice Powell. She goes on to describe how he reached it. And later, Senator Hatch said, you mean with the position of Justice Powell? And Judge Ginsburg said, the position I have stated here. You asked me how I justify saying that Roe has two underpinnings, the equal dignity of the woman idea and the personhood idea of individual autonomy and decision-making. I point to those two decision opinions as supplying the essential underpinning. And then she said, in taking the position I have in all of my writings on this subject, I must associate myself with Justice Powell's statements. Otherwise, I could not have written what I did. The point is that this is a matter on which she had written extensively. And therefore, it is not the case, A, that she was asked about the case and was responding, but rather she brought the decision up, and B, she used it to illustrate what she had already written about extensively. So I think that will help to clarify the record. We'll put those portions of the transcript in the record, and people can judge for themselves whether she violated the rule which she has laid down, a rule which you subscribe to with respect to giving hints or ideas about how you might rule in future cases. If you'd like to comment on any of that, you certainly may do so, but I doubt that you would want to do so. One of the other item that I would like to insert in the record is a memorandum, and this was discussed, I believe, in Senator Biden's questioning regarding a memorandum dated February 12th, 1982, regarding proposed intervention in Cantorino versus Wilson. And there were excerpts of that read to which you were asked to respond. I'd like to have the entire memorandum inserted in the record at this point so that people can judge for themselves.
Without objection, it will be made a part of the record.
Thank you very much, Mr. Chairman. Now, Judge Roberts, one of the themes in the statements of my colleagues, particularly on the other side of the aisle here, yesterday was an expression of concern that you might, as a Supreme Court justice, undo what they describe as progress. This progress is represented for my colleagues by some of the Court's decisions over recent decades, and also by some legislation. My colleagues expressed a heartfelt concern for preserving this progress. Another one of my Democratic colleagues endorsed a standard that a past member of this committee articulated for evaluating nominees. He asked, will the nominee expand or contract freedom? You recall that. Progress and freedom. I think any American would find it quite difficult to quibble with these two ideals. I do not think that you will find a member of the Senate who would not express support for both progress and freedom and for many of the specific reforms that have been discussed. But as I thought about those two words last night and about my colleagues' genuine concern for protecting what they understand as progress and freedom, I began to ask myself what those two words actually mean in the context of your nomination and the Court's function more generally. When can we say that a particular decision by the Supreme Court expands or contracts progress or freedom? Actually, it's a little more complicated as you stop and think about it. For example, earlier this year, the Supreme Court issued a decision that allows the government to take one private individual's property to transfer that property to another private individual or entity. The Court's majority held that such an action is consistent with the Constitution's public use requirement for takings of property, so long as there is some indirect benefit to the government, so long as, for example, the government expects to receive more tax revenues from the second party's use of the property. All of the most commonly described liberal members of the Supreme Court joined in the opinion. And I'm certain that the types of involuntary government-engineered development projects that this decision allows will be viewed by many as progress. I'm not so sure. Is it really progress for one more politically influential private party to be able to use the government's power of eminent domain to take another less politically connected individual's property? That this is constitutional so long as the government anticipates increased tax revenues. I don't think this precedent represents an advance of either progress or freedom, in other words. In 1975, the Court issued an important decision giving public school students the right to a hearing before they're suspended for disciplinary reasons. And the net effect of these decisions, as many school administrators and teachers have told me, has been to make school discipline much harder to implement and enforce. The procedures, for example, for removing a disruptive student from the classroom have become sufficiently involved that in many cases the school simply doesn't do it. The student remains in class and the other student's learning suffers. The writer David Frum has described this line of Supreme Court decisions as the bad king's Magna Carta. Well, many older teachers in particular can describe this, the decline in school discipline and order that followed from these decisions. And so I'm not sure that even though many would subscribe to the decision of the Court, that it really represents as an advance of freedom or progress, especially if most children are less free in their school environment. In 2003, the Supreme Court issued a decision that effectively prevents the government from outlawing child pornography if that pornography is made with computer-generated images of children. The effect of these decisions is that a whole class of child pornography effectively can't be prohibited. Many of those who work in the criminal justice system, particularly those familiar with sex offenders and their mindset, have expressed grave concern about the decision. They believe that the existence and availability of this kind of pornography can affect the behavior of certain sex offenders, that it sends them a message that their impulses are not shameful, but rather that they're shared by others and can be indulged. Again, I have no doubt that some view this decision as an advance of freedom. And again, I would disagree. A world where these types of sexual crimes occur with frequency is a world where parents are constantly afraid for their children, afraid to let them play outside alone, to go outside of their sight, even afraid to let them go on the internet. And I don't see this as an advance of freedom. The conclusion that I have, and there are other decisions we could point to as well, but what I've come to conclude is that it is not your function as a judge to decide how best to advance progress and freedom. That these are decisions that all Americans need to be involved in making, sometimes through their elected representatives. That the formula for creating progress and freedom in society is not predetermined, but rather both of these values require a balance of competing values. Society needs order and stability on the one hand, individual autonomy on the other. That there are a few absolutes. So really the question here is how you view your role as a judge with respect to this concept of advancing freedom and progress, especially since you cannot, for the most part, choose what cases come before you to decide. What is your take on your role if you were to become the Chief Justice of the United States Supreme Court in considering this notion of advancing freedom and progress through your decision making?
Well, Senator, judges and justices do have a side in these disputes. They need to be on the side of the Constitution. And in most of these areas, what the Constitution provides is that these sorts of policy debates, which approach is better suited to promote freedom or to promote progress, are vested in the legislative branch. There are areas where the Constitution sets aside certain areas, and the Bill of Rights and other protections of liberty, and says that these areas are beyond the reach of the policy-making branches, and judges and justices have the responsibility to enforce those provisions in the Constitution. But outside of that, judges and justices should not take sides in these disputes. I think people on both sides need to know that if they go to the Supreme Court, that they're going to be on a level playing field, that the judge is going to interpret the law, that the judge is going to apply the Constitution, and not take sides in their dispute. That's what this body is for in Congress and in the state legislatures, to resolve those types of policy disputes. And so long as the resolution is consistent with the Constitution, that's what the judges are there to ensure. And so long as they ensure that, the framers' notion was that freedom and progress would be advanced by allowing those decisions to be made by the people's elected representatives.
I appreciate that. You said in response to another question, you used the phrase "as applied." Now, most of the lawyers appreciate what you meant by that, but I wonder if you could elucidate, particularly for those who are not learned in the law, what the difference is between dealing with a case, an issue of constitutionality per se, or in an as-applied context, and how it is possible, for example, in case number one, to uphold the constitutionality of a law on its face, for example, and yet in case number two that comes down a few years later, to declare that in that situation the statute is unconstitutional as it's applied to the facts of that case. How can that be?
Well, the distinction is a basic one in constitutional law. If you have a facial challenge to a law, as we call it, or a per se challenge might be another way to put it, you're basically saying the law is unconstitutional without regard to the facts of the case, without regard to the record. Whatever the application might be, whoever the parties challenging it might be, there's something about the law so fundamentally flawed that it's unconstitutional, however it's going to be applied. That's a fairly narrow category of cases. The other category is so-called as-applied challenge. You have a law that you know is not facially unconstitutional, but it may be applied in an unconstitutional manner. An easy example, you have a normal statute that's perfectly constitutional. If it's applied in a discriminatory manner, it may be unconstitutional as applied in that case. If it can be applied in a constitutional manner, so long as the facts are a certain way, and if the facts turn out in the record not to meet those requirements, then it can be unconstitutional as applied. And in those situations, you do need to know what the record is. You do need to know what the facts are, because the challenge might be this law may be fine for other cases, but when you apply it to this case, when you apply it to this record or these facts, then it's unconstitutional. So it's a statute that is constitutional on its face can always be applied in an unconstitutional way, and so you can't give a categorical determination that there's no way in which that statute could ever be unconstitutionally applied.
And this is another reason why when you're asked, well, would you agree that a certain decision is a good decision and should be maintained as part of our jurisprudence and so on, in addition to not wanting to give a hint as to how you might rule on a case, to some extent it's impossible to say because you don't have the facts of the case before you, and the facts of case A could cause you to render a different decision than the facts of case B.
Well, that's right, and particular precedents obviously could be applied to variations on the fact situation that gave rise to that precedent, and sometimes those facts lead to a different result. Sometimes those facts don't, and they make, it makes sense to continue to apply it in a particular manner. But again, and I think most judges are of this view that the facts are a critical part of the resolution of any dispute.
I know perhaps to non-lawyers this can cause frustration. Well, just, tell me one way or the other. But judges have got to be fair and to make sure that they don't treat all cases as the same, because the fact differences could make the difference between your ruling one way or another in a case. And every litigant probably feels that their case is a little bit unique. Judges need to think about that, and certainly need to be willing to consider that this person's case might be unique, and therefore it has to be looked at in a way different than a similar, but perhaps not identical case.
Well, and of course that's a lot of how the law develops, and as lawyers arguing in court, a lot of what I used to spend my time doing was saying, this precedent doesn't apply. And the reason it doesn't apply is because these facts are different, and so you should reach a different result. Or arguing that this precedent does apply. Even though these facts are different, the reasoning still covers that situation. And then that leads to the next case and so on. And it's that sort of gradual development of the law that helps shape the rule of law.
Now, you've seen that each one of us have a couple of soap boxes that we like to mount, and after about 5 minutes of our opinion, then we ask you a question. I've got one of those for you, something that's been bugging me. There's been a lot of discussion about the Supreme Court's reliance or even reference to foreign law to determine the meaning of the United States Constitution. I just wanted to note a couple of the cases in which this was done recently. Case this year, Roper versus Simmons, in which the Supreme Court reversed a prior precedent and decided that it would be unconstitutional to execute a man who was 17 at the time that he brutally murdered a woman by throwing her off of a bridge. In deciding the case, the Supreme Court not only, in my view, engaged in questionable analysis of American law, it spent perhaps 20% of its legal analysis discussing the laws of Great Britain, Saudi Arabia, Yemen, Iran, Pakistan, Nigeria, and China. The court claimed that we ought not to, quote, stand alone on this issue and that we should pay attention to what other nations do when we interpret our Constitution. And in 1999, Justice Breyer argued that the court should consider whether a long delay in executing a convicted murderer, a delay, by the way, caused by his repeated and arguably frivolous appeals, should be deemed cruel and unusual under the Eighth Amendment. And he relied on the legal opinions of courts in Zimbabwe, India, Jamaica, and Canada. The trend, if it is to become one, is greatly troubling to me and to many of my colleagues. Our Constitution was drafted by the nation's founders, ratified by the states, and amended repeatedly through our constitutional processes that involve both federal and state legislators. It's an American Constitution, not a European or an African or an Asian one. And its meaning, it seems to be, by definition, cannot be determined by reference to foreign law. I also think it would put us on a dangerous path by trying to pick and choose among those foreign laws that we liked or didn't like. For example, many nations have a weak protection for freedom to participate in or practice one's religion. Iran and some other Middle Eastern nations come immediately to mind. But even a modern Western nation like France has placed restrictions on religious symbols in the public square. That would be highly unlikely to pass muster in U.S. courts. Should we look to France to tell us what the Free Exercise Clause means, for example? Even nations that share our common law traditions, such as Great Britain, offer fewer civil liberty guarantees than we do, and the press has far less freedom. Nations such as Canada have allowed their judges to craft a constitutional right to homosexual marriage. There's a lot more to say on this subject, but I wanted to hear from you. So my question is this. What, if anything, is the proper role of foreign law in U.S. Supreme Court decisions? And of course, we're not talking about interpreting treaties or foreign contracts of that sort, but cases such as those that would involve interpretations of the U.S. Constitution.
Well, I don't want to comment on any particular case, but I think I can speak more generally about the approach. I know Justices Scalia and Breyer had a little debate about it themselves here in town. That was very illuminating to get both of their views. And I would say as a general matter that there are a couple of things that cause concern on my part about the use of foreign law as precedent. As you say, this isn't about interpreting treaties or foreign contracts, but as precedent on the meaning of American law. The first has to do with democratic theory. Judicial decisions in this country, judges, of course, are not accountable to the people, but we are appointed through a process that allows for participation of the electorate. The president who nominates judges is obviously accountable to the people. The senators who confirm judges are accountable to the people. And in that way, the role of the judge is consistent with the democratic theory. If we're relying on a decision from a German judge about what our Constitution means, no president accountable to the people appointed that judge, and no Senate accountable to the people confirmed that judge. And yet he's playing a role in shaping the law that binds the people in this country. I think that's a concern that has to be addressed. The other part of it that would concern me is that relying on foreign precedent doesn't confine judges. It doesn't limit their discretion the way relying on domestic precedent does. Domestic precedent can confine and shape the discretion of the judges. Foreign law, you can find anything you want. If you don't find it in the decisions of France or Italy, it's in the decisions of Somalia or Japan or Indonesia or wherever. As somebody said in another context, looking at foreign law for support is like looking out over a crowd and picking out your friends. You can find them. They're there. And that actually expands the discretion of the judge. It allows the judge to incorporate his or her own personal preferences, cloak them with the authority of precedent, because they're finding precedent in foreign law, and use that to determine the meaning of the Constitution. And I think that's a misuse of precedent, not a correct use of precedent.
I appreciate that. We have precious little time to discuss your personal career and views, and I want to take just a couple of minutes to give you an opportunity to talk to us about a couple of things. I see by the record that you've represented at least one death row inmate on a pro bono basis, and I'd love to hear just about how you took that case and how you dealt with that case.
I don't want to overly expand my role. It was consistent with what I've done in other cases. There was a particular appellate issue that arose. The firm had been representing the inmate for some time. One of the senior leading partners at the firm, Barrett Prettyman, had been heavily involved in his case for many years. A particular appellate issue came up, and I was asked to get involved, and I was happy to do that and assist in that way. Again, it was kind of consistent with the general approach. It was in an area in which I had some experience and was happy to pitch in and help in that area.
There's a story, it may be apocryphal, and if so, you can disabuse us of it now, but is it really true that you were required to argue a case before the Supreme Court on 2 days' notice, and on that same day argued a case in the District of Columbia Circuit Court, or is that not a correct story?
No, that's the way it happened. I was scheduled to argue in the D.C. Circuit, and what happened is the Friday before the Monday argument, the clerk of the court called. We had a new lawyer who was not yet a member of the Supreme Court bar in the office, and I think we considered it kind of a pro forma matter. We were moving his admission pro hoc vice so he could argue that day, and I think this was the Supreme Court's way of telling us that they didn't consider it a pro forma matter, so we got notified the Friday night before the Monday argument that they were not going to grant the pro hoc motion, which is, of course, to let him argue the case even though he wasn't a member of the bar. And it fell to me to pick up that case to be prepared to argue it Monday morning. Then in the afternoon, I went and did the argument in the D.C. Circuit, which had been previously scheduled.
How'd you do in the two cases?
Well, the court got it right in each case. So I put it.
Enough said. You know, another thing that fascinated me in clerking for two of the most incredible jurists in United States history, Judge Friendly and Justice Rehnquist. I was going to ask you privately, but I just have to ask you, and perhaps it'd be illuminating for folks, particularly law students. What did you learn from those two very erudite men?
Well, I think different things. You pick up different things. With Judge Friendly, it was he had such a total commitment to excellence in his craft at every stage of the process. Just a total devotion to the rule of law and the confidence that if you just worked hard enough at it, you'd come up with the right answers. And it was his devotion to the rule of law that he took the most pleasure in. He liked the fact that the editorialists of the day couldn't decide whether he was a liberal or a conservative, and he would be chastised for the same opinion depending on which paper had read it as either that conservative judge or that liberal judge. And because he wasn't adhering to a political ideology, he was adhering to the rule of law. And his devotion to it went to the extent, and I know other of his clerks had the same experience. I do remember one time where he signed the opinion, and he kept writing it and writing it, and he finally decided it was not right, and so he wrote a dissent, and he circulated the best majority he could come up with and said, I don't agree with it, here's my dissent. And Of course, as you might imagine, the other two judges were persuaded by his dissent, and it came out that way. A sort of open-mindedness at every stage, the appreciation that it may not be the argument, it may not be the briefs, it may be down to the actual writing that reveals what he thinks the right answer is. And also, he did have an essential humility about him. He was an absolute genius. I mean, there's no doubt about it. And certainly, whatever he was reviewing, the decision of an agency, the decision of this legislature, the notion of saying, you know, we defer to them because it's their responsibility. I think everybody would have agreed we'd have a better result if we just let him make the decision, regardless of what it was. But he had the essential humility to appreciate that he was a judge and that this decision should be made by this agency or this decision by that legislature. And you read, when you read his opinions, he doesn't just sort of, you know, knock the pieces off the board. He marches through in a very careful way to let you know exactly how he reached the decision, why he went this way, if there was a difference among the precedents, why he chose this one, if there was a question of who has the responsibility, why he went that way. And it lays it all out in such a way that you can understand the result. And to this day, lawyers will say when they get into an area of the law and they pick up one of his opinions, that you can look at it and it's like having a guide to the whole area of the law. With the then Justice Rehnquist, who I clerked for the next year, I do remember doing a draft for him once and coming in, and he thought that it was sort of the first topic sentence of each paragraph was good, and the rest of it could be junked. And you know, I pushed back a little bit, as I hoped was appropriate. And he said at that point, he said, "Well, I'll tell you what. Why don't we put all this other stuff down in footnotes? We'll just keep sort of the first sentence of each paragraph, put the rest down in footnotes." And I figured, well, that was a fair compromise. So I go back and rework it and hand it to him with some pride, and he looks at it and he says, "Well, all right, now take out the footnotes." So one thing I learned from him was, I hope, to try to write crisply and efficiently, that a lot of extra stuff could be dispensed with. So many people mentioned it during his eulogies and at the sort of gathering of the clerks. His general approach to the balance between work and family life, and I think that was a very important lesson to learn at an early age.
Judge, thank you. I think that tells us not only something about you as a person, about your style of judging, but probably some good lessons for all of us. So thank you very much.
Thank you, Senator Kyle. Senator Cole.
Thank you, Mr. Chairman. Judge Roberts, yesterday you described your role as a judge as just an umpire, as you called it, calling balls and strikes. That's an interesting analogy for me, as I have more than most some personal experience with umpires and referees. But as all of us with any involvement in sports knows, no two umpires or no two referees has the same strike zone or call the same kind of a basketball game, and ball players and basketball players understand that depending upon who the umpire is and who the referee is, the game can be called entirely differently. When we look at real legal cases, I wonder whether or not your analogy works. For example, in our private conversation, I asked you whether the words of the Constitution must always be interpreted in the same way as the authors originally intended. For example, the 14th Amendment, which guarantees equal protection of the laws to all citizens, was written at a time when schools were, in fact, segregated based on race. And yet in Brown v. Board of Education, the Equal Protection Clause was interpreted to find segregated schools unconstitutional, and you, of course, have endorsed that decision. No one disagrees with that conclusion today, but would a neutral umpire, as you described yourself yesterday, have decided back in 1954 to expand the words of the Constitution outside of the strike zone? Would a neutral umpire have overturned a 58-year-old Supreme Court precedent and gone against the understanding of the authors of the 14th Amendment and also the views of almost half of the state legislatures at that time in making the decision that they made?
Well, Senator, I think the answer to your question is yes. research into the original understanding of the drafters of the 14th Amendment has expanded and changed quite a bit, and I think a very good case can be made about their views. But more importantly, the issue was the institution of public education wasn't as established at the time as it was in 1954, the time of the crafting of the amendment. And, you know, the framers spoke in broad language, and whether they specifically addressed the question of public education or not isn't the limitation. Their intent was not limited to the particular problem. They chose broad language, and they should be held to their word. And I think it is perfectly consistent with an original understanding to argue and to conclude that their original understanding meant that segregated schools were unconstitutional, not just in 1954, but at the time they enacted the amendment. Yes. I think a strong case can be made there. And yes, what was interesting about the Brown case, maybe it's my own perspective, but if you look at the arguments in that case, yes, John W. Davis, arguing for the board, was arguing on the basis of precedent in Plessy versus Ferguson, saying this is the established law. But so was Thurgood Marshall. He went in and he was arguing on the basis of more recent precedent, Sweat versus Painter, a more recent decision of the court about law school separate but equal. And he was saying you need to build on that more recent precedent in addressing this case. So the court was not changing the strike zone. That wasn't the way Marshall presented his argument, and it wasn't necessary for them to say we're changing the rules of the game. What was necessary for them to do, and what Marshall was urging them to do, was to get it right when they had gotten it wrong in Plessy.
Judge, back in 1954, clearly, the Supreme Court justices were willing to step outside the box, to break new ground, to do something that no court, no legislature, no president had done before, and strike out in an entirely new and positive direction for this country. They were not umpires simply calling balls and strikes. They were breaking new ground, and they did so in the best interest of our country, didn't they?
Well, of course it was a dramatic shift. And the overruling of Plessy versus Ferguson was exactly that. My point is simply that if you look at the Brown decision, it is more consistent with the 14th Amendment and the original understanding of the 14th Amendment than Plessy versus Ferguson. And it's based on the conclusion that the separation of the races in the schools was itself a violation of equal protection. In other words, it's not a departure from the 14th Amendment. It was a departure from the...
But it was
Plessy.
groundbreaking.
Certainly.
One more observation, Judge, about your analogy of the judge as an umpire, neutral umpire. You're 50 years old, you bring great life experience to the bench, Judge, and don't you and all judges bring their own life experiences, their philosophies to the bench in deciding cases? Or would you have us believe, and if not, you can correct that judges merely operate as automatons?
Not automatons, no, Senator. I appreciate that judges don't. And, of course, we all bring our life experiences to the bench. But I will say this, that the ideal in the American justice system is epitomized by the fact that justices do wear the black robes. And that is meant to symbolize the fact that they're not individuals promoting their own particular views, but they are supposed to be doing their best to interpret the law, to interpret the Constitution according to the rule of law, not their own preferences, not their own personal beliefs. That's the ideal.
And isn't it also true that to a large extent the greatest men in our history, judicial, executive, legislative, have been men and women with both great minds and great hearts?
Absolutely.
Judge, in the aftermath of Hurricane Katrina, we all saw that those who suffered the most were those who had not been able to take advantage of the great opportunities that our great country has to offer. As we found out, those without employment opportunities and educational opportunities simply did not have the means to escape the storm and the flooding. As you seek to become the head of the judicial branch, as you seek the position of Chief Justice of the United States of America, what role would you play in making right the wrongs revealed by Katrina? And what role do you and the judicial branch play in making sure that we as a nation keep on moving forward towards providing equal opportunity to all Americans?
The last part of your question, Senator, is, of course, really what's carved on the entrance to the Supreme Court, equal justice under law. That is the commitment physically embodied in the Supreme Court, and it's a commitment in the Constitution. And I think the most important thing the Supreme Court can do and the judicial branch can do is to uphold the rule of law. That is I tried to point this out in my statement yesterday. That is the key to making all the rights that are in the Constitution, all the rights that legislators may confer on citizens, that's the key to making them meaningful. The difference between our system and our Constitution and the Soviet Constitution that President Reagan used to talk about, it has wonderful rights in it too. They didn't mean a thing. Because there was not an independent Supreme Court, an independent judiciary to enforce those rights.
Sure.
We do have that, and that's the reason that we have been able to make progress in the area of rights and not had just empty paper promises.
Yes.
So to the extent you're talking about the injustices in society and the discrimination in society, the best thing the courts can do is enforce the rule of law and provide a level playing field for people to come in and vindicate their rights and enforce the rule of law.
But in spite of all of our laws and all of our rules, we still saw what happened down in New Orleans. And the people who were left behind were people who had not had educational or employment opportunities. And the question I asked was whether you, as a person who aspires to become the Chief Justice of the United States, sees a particular role other than continuing the role that you observe we are following now, particular role for improving our ability to respond to the needs of those people who live under those circumstances.
Well, the courts are, of course, passive institutions. We hear cases that are brought before us. We don't go out and bring cases. We don't have the constitutional authority to execute the law. We don't have the constitutional authority to make the law. Our obligation is to decide the cases that are presented. Now, I'm confident, just in the nature of things, that there will be cases presented arising out of that horrible disaster of all sorts. And many of those will be federal cases, I'm sure. Others will be in the state courts. And again, the obligation of the federal judiciary and the state judiciary is to make sure they provide a place where people can have their claims, their litigation decided fairly and efficiently according to the rule of law. That's the appropriate role for the judicial branch.
All right. Judge, do you believe that reasonable people can disagree on Roe v. Wade? Regardless of what you think of the decision, do you believe that there is an intellectually honest approach on the other side that is worth respecting?
I certainly agree that reasonable people can disagree about that decision, yes.
And you do obviously respect people on the other side of the issue?
Yes.
In Russ v. Sullivan, as Deputy Solicitor General, you signed a brief in which you wrote, and I quote, "The court's conclusions in Roe that there is a fundamental right to an abortion and that government has no compelling interest in protecting prenatal human life throughout pregnancy find no support in the text, structure, or history of the Constitution," unquote. So, does this quote jibe with your statement that you understand that reasonable people can disagree?
Well, I think so, Senator. The position that you're reading from there was the position of the administration. I was one of 9 lawyers on the brief in that case. It was reflecting the position that had been advanced in 4 prior cases up to that point by the administration, and we were reiterating that position. This was before the Supreme Court issued its decision in Casey. That was the view of the administration and the conclusion. I don't think there's anything in there that suggests we think or thought that anybody at that time who disagreed was unreasonable. That was our legal position. The other side is obviously presented in those cases.
Well, you are saying here that there is no support in the text, structure, or history of the Constitution for that position. That's pretty flat out, pretty straight, pretty black and white.
And in those cases, the other side argued that there was. And I don't think there's anything in either of those views that suggests you don't think that reasonable people can take different positions on those questions.
You have today suggested on numerous occasions that the things that you represented in writing or in opinion back in the 80s and into the 90s, working for the Reagan administration and working for the Attorney General, and then finally working as Deputy Solicitor Attorney General, were in many cases the opinions of people for whom you worked, not necessarily your own. I assume, therefore, there are those opinions that you're prepared to disavow?
My view in preparing all the memoranda that people have been talking about was as a staff lawyer. I was promoting the views of the people for whom I worked. And in some instances, those are consistent with personal views. In other instances, they may not be. In most instances, no one cared terribly much what my personal views were. They were to advance the views of the administration for which I worked.
Well, I appreciate that. And now that we're talking about you in an entirely different situation, of course, our curiosity is which of those positions were you supportive of, or are you still supportive of, and which would you disavow?
Well, at this point, of course, we're now 23, 24 years later. I would not, I would have to address each of those positions anew. I wouldn't try to transport myself back 24 years and say, what did you think 24 years ago? And that would require me to look at and examine all those things. And of course, it's not how I would look at the issue if I were a judge. If I were a staff lawyer advancing a particular view, it's one thing. As a judge, I would want to confront the issue with an open mind, to fully and fairly consider the briefs and arguments of all parties, to consider the record. We've talked today about how important a record is in a particular case. Consider the law and the precedents. And of course, the law and the precedents have changed in many of these areas dramatically over the past 24 years. I'd have to consider all those before reaching a conclusion in any of those particular areas.
Sure. It would be helpful to many of us to know which of those positions you took then no longer represent the position that you would take today. I think that would show a change as we grow and develop and experience life. That would be illuminating and enlightening to many of us to hear what some of those positions you took then no longer are represented in your thought process today. Judge, as we all know, the Griswold, Connecticut case guarantees that there is a fundamental right to privacy in the Constitution as it applies to contraception. Do you agree with that decision, and that there is a fundamental right to privacy as it relates to contraception? In your opinion, is that settled law?
I agree with the Griswold Court's conclusion that marital privacy extends to contraception and the availability of that. The Court, since Griswold, has grounded the privacy right discussed in that case in the liberty interest protected under the Due Process Clause. That's the approach that the Court has taken in subsequent cases, rather than in the penumbras and emanations that were discussed in Justice Douglas's opinion. And that view of the result is, I think, consistent with the subsequent development of the law, which is focused on the Due Process Clause and liberty rather than Justice Douglas's approach.
Well, I'm delighted to hear you say that, because, as you know, many constitutional scholars believe that once you accept the reasoning of Griswold and find that the Constitution does contain a right to privacy and a right to contraception, that you've essentially accepted, scholars have said this, essentially accepted the basis for the Court's reasoning and decision on Roe, that a woman has a constitutionally protected right to choose. These scholars reason that it follows logically that if a woman's right to privacy and her control of her body includes the right to contraception, then it also includes a woman's right to choose to terminate her pregnancy. I'm not sure whether you wish to comment on that. I just wanted to point out to you something that I'm sure you're familiar with, is that there is, in constitutional thought, a follow from Griswold to Roe.
Well, I feel comfortable commenting on Griswold and the result in Griswold because that does not appear to me to be an area that's going to come before the court again. It was surprising when it came before the court in 1965, I think, to many people. The other area is an area that is, as to quote Justice Ginsburg from her hearings, live with business. There are cases that arise there, and so that's an area that I do not feel it appropriate for me to comment on.
I appreciate that. Judge, as we all know, you were originally nominated to replace the first woman ever to sit on the Supreme Court, Sandra Day O'Connor. There was a lot of speculation when she announced her retirement that the President might choose a woman to replace her. And she even suggested a little disappointment, not with you, but with the fact that a woman was not chosen. Had the President told you that the selection was down to you and an equally qualified woman for the post, but that he thought a woman was needed, would you have seen that as a reasonable conclusion on his part?
Oh, I certainly think presidents have and will consider a broad range of issues and characteristics and qualifications in selecting their nominees, and that's certainly one for a president to consider.
All things being equal, in terms of qualifications, would you be pleased if the President chose a woman to replace Sandra Day O'Connor?
With the upcoming vacancy?
Yes.
I just wanted to make clear we weren't talking about this one. I don't think it's appropriate for me to comment in any way about the President's future selections, other than to say that I'm happy with his past ones.
You're not an automaton. Judge Roberts, in an October 3rd, 1983 memo, you wrote that while you served as Associate White House Counsel for the Reagan administration, you expressed support for judicial term limits. You did specifically support the idea of limiting judicial terms to 15 years, and you said, I quote, to ensure that federal judges would not lose all touch with reality through decades of ivory tower existence, unquote. And do you still support, in theory, the idea of judicial term limits?
You know, that would be one of those memos that I no longer agree with, Senator. I didn't fully appreciate what was involved in the confirmation process when I wrote that. You know, the sentiments that were expressed there, I think, are certainly something that's worth discussing. Perhaps my basic point was when the framers established a system of life tenure, people didn't live as long as they do now. You know, I do think there are concerns, though, that I may be a little bit more sensitive to now than I was then, and they have to do with sort of a definite cutoff point. I'm not sure that's healthy for the institution of the judiciary, for people to know, for example, well, it's sort of like, as you say, term limits, that if we wait another year, this judge will be gone or that justice will be gone. I'm not sure today, from where I sit, that is a good or healthy thing for the judiciary.
So you do not support term limits anymore?
I have to say I do not, because I do think that restriction at the end, so litigants could look and shape their litigation in light of who they think the judges or justices might be. I think that's not a healthy development. I would note that if I'm remembering the memo correctly, I think it was a proposed constitutional amendment, which I'm not sure, right? But I think that obviously is a policy choice that the Constitution allows to be pursued through that process.
All right. Judge, as you know, confronted with a legal problem, most American families, unlike wealthy and families and very large businesses, lack the resources to hire the largest and most preeminent law firms to do their bidding. And do you agree that for our nation's working people, securing civil justice is often rendered substantially much more difficult because it simply does cost too much? Do you have suggestions for addressing this issue? Do you worry that captivating national events such as the O.J. Simpson and Michael Jackson trials reinforce the view that in this country justice can be for sale and available to those who can afford it?
You know, I do think that the availability of legal services is not as broad and widespread as it should be. There's so many things in areas where I think lawyers could make a valuable contribution, but it's too expensive. And there are a number of responses that I think the bar should be taking. Obviously, for those at the lowest end of the income scale, I think there's an obligation to provide pro bono legal services. I think the big firms, little firms, medium firms, everybody needs to get involved in that. There's not enough appreciation about how you can do that. For example, everybody thinks in terms of bringing a big case, litigation. You know, lawyers who do estate work can provide extremely valuable pro bono services. Lawyers who do tax work can provide extremely valuable pro bono services. The whole range of services. Corporate work. I know lawyers in my old firm would do a lot of pro bono services, helping set up nonprofit organizations, ensuring that they're complying with the law. People need to be a little more creative in the ways in which they can help. I regard that as an obligation of the bar, and I do think that, in fact, in many cases, the situation you get is, you know, the people at the lowest end have access to pro bono services. People at the highest end can pay, and it's the people in the middle who are left without legal services that could be extremely valuable. And I do think the bar needs to do more. I think firms need to do more. Individual lawyers need to do more.
Judge Roberts, as you know, over the last 2 decades or so, there have been several bills introduced in Congress to strip the Supreme Court and all other federal courts of their jurisdiction over many issues. These bills are generally sponsored by people who are unhappy with various court decisions, including decisions on things like school prayer, remedies for school desegregation, and even a woman's right to choose. While you served in the Justice Department and on the White House counsel's office in the Reagan administration in the 1980s, you did state that you believed that bills stripping the court's jurisdiction were constitutionally permissible. Do you still hold this view? Do you think it's the right way for us to go, to allow our legislatures to strip your authority to review cases?
Well, I know the memos to which you're referring make the point. Answer your second question. I said that they were a bad idea. They were a bad policy. I'd been asked earlier when I was back in 1981, I believe, when I was working in the Attorney General's office, to present to him an affirmative case for the proposition that these proposals were constitutional. He was getting an opinion that they were unconstitutional. He had to make that decision for the department's position. He wanted me to argue the other side. And I did. I prepared a memorandum presenting the best argument I could that these proposals were constitutional. The 2 memos to which you refer in the White House where I suggested I thought they were suggest that my memo persuaded me, if nobody else. The Attorney General adopted instead the contrary position. And I think my views may have had something to do with the proximity to my own advocacy at the time. As I say, I did say they were a bad policy. The reason I thought they were a bad policy is because they lead to a situation where there's arguable inconsistency and disuniformity in federal law. If you don't have the Supreme Court with jurisdiction to address that, then you get different decisions, and that's bad policy. If I were to look at the question today, to be honest with you, I don't know where I would come out. I think one of the questions I would have is whether these concerns I had that I labeled as policy concerns might more appropriately be considered legal arguments. In other words, not a policy dispute, but a legal argument. That's the way the opinion of the Office of Legal Counsel that the Attorney General agreed with viewed it. They said the fact of disuniformity and inconsistency is a legal argument against the constitutionality. It's not simply a bad policy decision, and I'm not sure where I would regard that determination today.
Really? Are you saying that you're not sure where you would come out if you were faced with the decision to go along with or to fight legislative attempts to take away the court's authority?
Oh, I don't think on the question of legislative attempts, I think my view is the same now as it was 24 years ago, which is that it's a bad idea. It's bad policy. I was talking about the other question about whether it's constitutional or not. And on that, of course, I don't think I should express a determinative view because, as you know, these proposals do come up and one may be enacted. And if that is the case, then I'd have to address that question on the court. Could be on the court I'm on now or another court.
In that case, or in this case, your heart might tell you that it's a bad idea. Your mind might tell you it's constitutional.
Well, I don't know what my mind would tell me, yes.
Possible.
But I feel comfortable with the conclusion, as I was 24 years ago, that it's a bad idea. They're bad policy.
Judge, since your nomination, literally, as you know, tens of thousands of pages of your writings as a young White House aide have been released and looked at very carefully. In some of these writings, you took very pointed positions, as we've discussed, some political, some constitutional, and some that have raised eyebrows. I also think about myself when I was in my 20s and then when I was at the age which you are now and who I've become today, and how I have changed, matured, and hopefully grown as I've gotten older. I'm sure when you've had a chance to review some of your old work as part of this process, that there are things that you wrote back then that make you cringe, perhaps, today? Are there positions you took back then as a 20-something lawyer that you would not take today? Can you give us a couple of examples of positions that you took then that, as you have grown and developed, and as you are now sitting before us to be the Chief Justice of the United States of America, that you are today not the person that you were back when you were 20-something?
Well, we've talked about the term limits for judges. More generally, as I look at all of these documents and the numbers, somebody said 80,000 pages. It's a little daunting. I don't know that there are particular issues. I mean, you have to remember, this is 23, 22, 24 years ago. In many of these cases, not only have I changed, the law has changed dramatically in more than 2 decades. You know, I'm sure, and again, of the many that have been released, I will say that it's really only a handful that have attracted attention for one reason or another. And I do think if you look at the whole body of work, that I would hope people would leave that with a favorable impression. Certainly, there are many areas where it appears that I knew a lot more when I was 25 than I think I know now when I'm 50. I had a lot of different experiences in the intervening period that give you valuable perspective. In that intervening period, for example, I left the government, went out in the private sector, litigated a lot of cases against the government. You do get a different view of things when you're on the other side. I think that's extremely valuable. I hope, as you suggest, I've grown as a person over that period as well, and that also gives you some perspective. And that type of a perspective might cause somebody to moderate their tone with respect to some issues and in some areas, and I'm sure that's the case. I certainly wouldn't write everything today as I wrote it back then, but I don't think any of us would do things or write things today as we did when we were 25 and had all the answers.
I thank you, Judge Roberts. Thank you, Mr. Chairman.
Thank you, Senator.
Thank you, Senator Cole. Senator DeWine.
Thank you, Mr. Chairman. Judge, good afternoon.
Afternoon.
Judge, the good news is that I represent the halfway point.
On the first
The bad news is it's the first round. Judge, I want to ask you about one of your more important, probably least understood, not by you, but least understood by the public's role if you are confirmed as the Chief Justice, and that is your job to appoint the members of the FISA Court. Judge, as you know, in 1978, Congress passed the Foreign Intelligence Surveillance Act. This law, of course, set up the FISA Court. As you well know, this is the court that our intelligence agents go to when they want to obtain wiretaps or search warrants against terrorists and foreign spies. Very important court. court that meets in secret, court that deals with the most important national security matters that we have really in our country, but also a court that deals with our precious civil liberties. And Judge, because it's a court that meets in secret, it doesn't have the public scrutiny, doesn't have the glare of publicity, and quite candidly does not have much oversight. So I would like to know, besides what's in the statute sets out that it will be your job to select the 11 judges who sit on the FISA court, the 3 judges who sit on the FISA Court of Review. There are certain guidelines in the statute. But besides that, I wonder if you could tell us what your criteria will be when you select these men, these women who will serve on the court. And I wonder if you could give me your personal assurance that this will be something that will be very important to you, that you will take a hands-on approach, and that you will be very personally involved in, because really it is a question of the utmost national security. These are people who are going to make sometimes life and death decisions for our country.
I appreciate that, Senator, and if I am confirmed, that is something that I will address and take very seriously. I think, as in many areas, my first priority is going to be to listen, to learn a little bit more about what's involved. I'll be very candid. When I first learned about the FISA court, I was surprised. It's not what we usually think of when we think of a court. We think of a place where we can go, we can watch, the lawyers argue, and it's subject to the glare of publicity, and the judges explain their decision to the public, and they can examine them. That's what we think of as a court. This is a very different and unusual institution. That was my first reaction. I appreciate the reasons that it operates the way it does, but it does seem to me that the departures from the normal judicial model that are involved there put a premium on the individuals involved. I think the people who are selected for that tribunal have to be above reproach. There can't be any question that these are among the best judges that our system has, the fairest judges, the ones who are most sensitive to the different issues involved, because they don't have the oversight of the public being able to see what's going on. Again, to be perfectly honest, it is a very unusual situation, and I do think it places a great premium on making sure that the best qualified people for that position are selected.
Well, I appreciate your personal attention to that. I know how important you know it is, Judge, and I would just add one more comment, that that court, as all courts do, but even more so, not only makes decisions, not only decides whether to issue the warrant or not, but it's the feedback that the Justice Department gets and that law enforcement agencies get that tells them what they can do and can't do. And that feedback is unbelievably important, and it affects the intelligence operations in this country, and just vitally, vitally important. Let me move, if I could, to something that's very important to me and to all of us, and that is the First Amendment. Certainly, Judge, there's no right in our Constitution that is any more important than the freedom of speech. In a sense, it's the foundation of our democracy. It is the right upon which other rights are built. It's the right that guards our liberty and preserves our freedom. At the heart of the First Amendment is the idea that people have a right not only to speak their mind, but also to be heard. I'd like to talk to you a little bit about that and ask you a question. The case, I think, that most eloquently talks about the public square where we engage in speech is Hague versus CIO, 1939 case, which you're well familiar with. I want to quote it very briefly. Wherever the title of streets and parks may rest, they have immemorially been held in trust for the use of the public, and time out of mind have been used for purposes of assembly, communicating thoughts between citizens, and discussing public questions. Such use of the streets and public places has, from ancient times, been a part of the privileges, immunities, rights, and liberties of citizens. End of quote. Judge, I want to be honest with you and say that as of late, I feel that we're seeing a disturbing trend when it comes to speech in the public arena. I want to give you some examples. In a recent case, a Wisconsin woman was kicked off a city bus. And this is what she was kicked off a city bus for doing. She was trying to distribute a book containing Bible stories to individuals sitting next to her. Another case that's repeated time and time again across this country and has been for many years in towns and cities, villages across the country. Individuals are prohibited from placing political signs. It could be not just for candidates, it could be for a school levy, against a school levy, on their own property, except during specified times and in specified ways. Government tells them so many days before the election, you can't put that up there until so many days before the election. Not just for candidates, but for bond issues, whatever the issue that they want to talk about through their own political speech on their own property. Another example, in many public, people who wish to exercise free speech in many public places, these individuals are forced into so-called free speech zones, which many times are far away from the event that they wish to protest about. So far away that they can't ever be seen or ever be heard, out of sight. Again, we go back to the issue of you have to be heard. In one recent case, the New York City Housing Authority refused to let a woman conduct Bible studies in the community center of a housing project, even though the community center was used for a host of activities, even weddings. I must say, in that case, she actually won the case. So I'm concerned when I see these restrictions. I think at the core of the First Amendment is the idea that individuals should be able to speak and be heard in public places. Now, Judge, I know you can't tell us how you'll decide any particular case. I'm not asking you to do that. But it is important to me that you talk to us a little bit about how you will evaluate these cases involving the right to speak in public places. Public places such as buses, metro stations, city sidewalks, public parks. And tell us, if you could, Judge, what factors will you consider when deciding restrictions on speech in the public square as we traditionally know it, and what is proper under the First Amendment and which ones are not? What tools will you use to decide that?
Well, again, of course, without commenting on any of the particular hypotheticals
Right.
or actual
I'm not
cases.
Asking, and they're all real cases, but I don't want you to talk about that.
I do think, though, first as a general matter and then to get into the law, that it is important that people keep a basic principle in mind when they're addressing these types of concerns. And it's not a provision in the Constitution, it's not a provision in a law, but it's a basic American approach that I think is important, and that's captured in the expression, it's a free country. And when you're talking about what people can say, signs they can put up, what they can do, I think people as a general matter need to appreciate that it's a free country, and it's a wonderful thing that people can say things in the public that you may not agree with, because you, of course, have the same right. Now, the particular mode of analysis that the Supreme Court uses in addressing these types of public speech issues is to some extent unsettled. Public forum doctrine, as it's called, for many years you tried to characterize an issue as, is this a public forum? Is it a quasi-public forum? Is it a private forum? And the definition sort of carried with it the conclusion about what could be allowed, and many of the justices thought that the reasoning was awfully circular. I remember years ago I argued one of the cases in the Supreme Court about post office and what could be done in a post office area, and whether the restriction of that area to postal business meant they could exclude people who wanted to engage in political speech. And I remember thinking at the time that the precedents were very unsettled, and I'm not sure that the Court has made much progress since then. But you do try to focus a little bit on whether you're dealing with a public forum, one that has traditionally been open to expression, and if it has, then any restrictions on expression are going to be subject to a very exacting standard before they'll be upheld. If it's a more limited public forum, it's only been open for certain types of speech, or the nature of the forum requires there to be a restriction. That was the government's argument in the post office case I litigated. Then it's a less demanding standard in those situations.
Let me just follow up with that with a short question. If you could give me just a reaction to this, if I could. Do you think the First Amendment is flexible enough in the year 2005 to account for what I believe, at least, is the shrinking public square? Now, I know we have the internet, we have TV, we have radio, a lot of things that we didn't have when our founders wrote the Constitution. But I think there is a shrinking public square. What do I mean by this? Someone who wants to run for school board today, someone who wants to support a school levy, oppose a school levy. When you and I were growing up, you're younger than I am, but when we were growing up in the Midwest, you could go downtown, if you support a school levy, let's say, you could go downtown and pass out literature in front of the hardware store or the grocery store. And that was a public place because it was a sidewalk. And you knew everybody in town was probably going to go by there. And if you lived in a city, there were communities in the city where you could do the same thing. Today, most people, we just don't live that way. Most people don't. Some do, but most don't. Today, people get in their car, and if they go to the grocery store, they go to a strip mall, and they go to a grocery store that is surrounded all by private property, and the people who own that strip mall say you can't come on, usually say you can't come on and distribute any literature of any kind on this facility, and basically they're upheld in that right because it's private property. Or they go buy their clothes or everything else, their hardware, they go in a big mall. And that mall clearly is a Supreme Court case right on point that says that they can be excluded. So the traditional public forum as we know it is really shrunk. Does the court take that into consideration when they look at the precedents, they look at all the decisions that have been made? How does that, without deciding any case or talking about any specifics,
well,
it's a different world we live in today.
Well, I appreciate the point, and I do know that even the analysis in this particular area, one of the factors that the court considers is the availability of alternative avenues for expression, and a concern if they're cutting off a particular mode of expression, a particular avenue, are there alternatives available? And I think that's a very important consideration. I think you're quite right that this is one of those areas in which technology is going to figure in a very prominent way. And the question of whether this type of analysis that grew up when you're talking about a public square, a town hall type thing, applies in the internet situation, and whether there's changes that do need to be made in the analysis.
Let me talk, since you talked about the internet, let me turn to a disturbing trend in regard to the internet, and that has, quite frankly, to do with pornography. We have passed several bills in Congress. The Communications Decency Act to protect our children. Supreme Court struck it down. I'm not going to ask you a comment about that. A few years later, we passed the Child Online Protection Act, again with the intent to protect our children. Again, the court struck it down. Unlike the traditional public square, the internet has really become a place for the distribution of some, I find, very troubling material, and that is pornography. And I guess what bothers me about these cases is they fail to account for something that, to me at least, is very relatively simple. And that is that at the core of the First Amendment is, to me at least, the protection of political speech, speech on matters of public concern I've talked about before. But it seems to me that pornography is different, particularly pornography that children can easily access. It seems to me that should be treated differently than political speech. Famous case, Young versus American Mini Theaters. In that case, the court upheld zoning regulations on adult theaters. Justice Stevens, hardly a right-winger, had this to say, and I quote, "Even though we recognize that the First Amendment will not tolerate the total suppression of erotic materials that have some arguably artistic value, It is manifest that society's interest in protecting this type of expression is of a wholly different and lesser magnitude than the interest in untrammeled political debate. Few of us would march our sons and daughters off to war to preserve the citizen's right to see, quote, specified sexual activities, end of quote, exhibited in the theaters of our choice, end of quote. And Judge, in light of that quotation, here are my questions. Are there or should there be different levels of speech under the First Amendment? Should pornography, for instance, be treated with less regard than Mark Twain's Huck Finn? And how would you have confirmed the Supreme Court decide what protection, if any, certain kinds of expression are entitled to under the First Amendment?
Well, Senator, it's my understanding under the Supreme Court's doctrine that pornographic expression is not protected to the same extent, at least, as political and coarse speech. And the difficulty that the Court has addressed in these different areas, of course, is always defining what is or is not pornography and what is entitled to protection under the First Amendment and what is not. That question is sort of antecedent to the question of what the level of protection is. We determine whether it's entitled to First Amendment protection in the first place. And certain types of speech, like child pornography, the Court has determined are not entitled to protection under the First Amendment. There are different categories, and the Court has struggled over the years in figuring out how to determine those categories and what belongs in what category, and beyond that, I don't think I can give a more precise answer.
Judge, let me turn to the area of congressional power. It's been talked about before here, but I want to talk about a little bit more. And really, this has to do with federalism cases. As you know, the Court has handed down a number of cases that have restricted the power of Congress to pass important legislation. The Court has struck down portions of the Violence Against Women's Act, the Americans with Disabilities Act, the Age Discrimination and Employment Act, and the Religious Freedom Restoration Act, just to name a few. In some of these cases, the Court restricted Congress's power under the Commerce Clause. In some, it relied on the 11th Amendment, and in some, it cited Section 5 of the 14th Amendment. The particular provision is not that important for this discussion. Let me be perfectly frank. I think there's some problems with these decisions. I think it is wrong for judges to take on the role of policymaker. I realize that if a statute is blatantly unconstitutional, judges have to do their duty. But I think for the reason I'm going to discuss in a minute, that was not true in these cases. I want to cite one example, and that is, just because of time, I only can go through one, and that is the Garrett case. 5-4 decision, Board of Trustees versus Garrett. As you know, this case involved a woman who said that she had been discriminated against because she was disabled. She was employed by the state of Alabama. She sued the state under the Americans with Disabilities Act. The Supreme Court threw out the suit, holding that there was no evidence that the states discriminated against the disabled in employment decisions. I think the problem with Garrett is the Court ignored findings by Congress. There were other cases that have been decided where we didn't have findings. You're familiar with those. I understand the Court's decision. I might like them or not like them, but I understand that. This case, we made findings. While we were considering the Americans with Disabilities Act, we held 13 hearings, and we set up a task force that held hearings in every state. It was attended by more than 30,000 individuals. Based on these hearings, we found 300 examples of disabled individuals being discriminated against in employment decisions. We found that 2/3 of all disabled Americans between the ages of 16 and 64 were not working at all, even though a large majority of them were capable of doing so. And we found that this discrimination flowed from stereotypic assumptions about the disabled, as well as, quote, purposeful, unequal treatment, end of quote. All findings by this elected Congress of the United States. In Garrett, however, the Court said this was not enough. It rejected our fact findings. holding that we had not pointed to any evidence that the states discriminated in employment decisions against the disabled. Judge, you have stressed repeatedly in your writings and your opinions, and I have a great deal of respect for you and appreciate these writings and opinions. You stressed the limited role that judges must play in our system of government. I applaud you for that approach. It's important for me to ensure that you still hold to this belief. In your opinion, what role should a judge play when reviewing congressional fact findings? In your view, how much deference do congressional fact findings deserve? I understand you're not going to talk about this case or any of the cases I've just cited. I want to lay that kind of as the predicate. I want to tell you where I'm coming from. But just talk in general about when you see fact findings by Congress, when we've held hearings, when we've established the record, how do you approach it? What are the tools that you use, Judge, based on the precedents and based on what you think the role of the judge is?
Well, again, and of course, without getting into the particulars, the reason that congressional fact-finding and determination is important in these cases is because the courts recognize that they can't do that. Courts can't have, as you said, whatever it was, the 13 separate hearings before passing particular legislation. Courts, the Supreme Court can't sit and hear witness after witness after witness in a particular area and develop that kind of a record. Courts can't make the policy judgments about what type of legislation is necessary in light of the findings that are made. So findings play an important role, and I think it's correct to say under the law in this area and others they're neither necessary nor necessarily sufficient, but I know as a judge that they're extremely helpful when there are findings, and judges know when they look at those that they're the result of an exhaustive process of a sort that the court cannot duplicate. We simply don't have the institutional expertise or the resources or the authority to engage in that type of a process. So that is sort of the basis for the deference to the fact-finding that is made. It's institutional competence. The courts don't have it. Congress does. It's constitutional authority. It's not our job. It is your job. So the deference to congressional findings in this area has a solid basis. Now, in the particular area you're talking about under Section 5 of the 14th Amendment, in the Garrett case, there are, of course, the more recent cases that you know of, the Tennessee against Lane and the Hibbs case, Nevada against Hibbs, where the court did defer to the fact-finding in those cases, and particularly in the Hibbs case focused on the legislative recognition based on its examination of the factual record developed at hearings about the statute that was at issue there and the particular approach that they were taking to remedy discrimination under the 14th Amendment, which is the authority that Congress has. Now, the legal requirement that the court has articulated there came, of course, from the City of Bernie case. The remedial approach has to be congruent and proportional. Justice Scalia signed on to that approach in the City of Bernie case. In the Lane case, he said he'd changed his mind and he no longer agreed with that. If any area of the law where Justice Scalia is changing his mind has got to be one that's particularly difficult and one that I think is appropriately regarded as still evolving and emerging. And so I don't know if the more recent cases in Lane and Hibbs represent a swinging of the pendulum away from cases like Garrett and Kimmel on the other side, or if it's simply part of the process of the court trying to come to rest with an approach in this area. But it is an area that the court has found difficult, and just as a general matter, I think when you get to this point of reweighing congressional findings, that starts to look more like a legislative function, and the courts need to be very careful as they get into that area to make sure that they're interpreting the law and not making it.
Well, Judge, I appreciate your answer, and I'm going to move on, but I would just say that one of the more disturbing things to me about Garrett is that the dissent and the majority opinion got into a dispute, verbal dispute about what the facts were. And, you know, dispute about the facts, that seems to me that's not usually what the Supreme Court gets involved in. And it seems if there's a dispute in the facts, you would normally defer to the fact finder, Congress. Let me take off on Garrett, maybe talk about another way to get at this. Rather than focus on the problem caused by Garrett, maybe there's another way to solve some of the problems that would be raised by this. Congress still has the power to protect the disabled under the spending clause of the Constitution. We have the power of the purse. In South Dakota versus Dole, we wanted to establish a national drinking age of 21. You're well aware of that. It was upheld by the court. We did it through the power of the purse in the Dole case. I just wonder if Congress might be able to use this approach to require the states to waive their immunity from suit under statutes like the Americans with Disabilities Act. It seems to me that under the spending clause, we have at our disposal the power to protect the disabled, to protect other groups, and effectively overturn cases like Garrett and these other cases that limit legislative power. You seem to take that approach in a case entitled Barber versus Washington Metropolitan Transit Authority. That case concerned a disabled person who was suing a state entity under the Rehabilitation Act. In that case, you held that the suit could go forward even though the state entity was immune from suit under the 11th Amendment. In your view, the state entity had agreed to waive its immunity in exchange for receiving federal mass transit dollars. I think this case is important. It's important to me, at least, Judge. Seems to show us what you think about Congress's power under the spending clause, and also gives us a model, I think, for how we might be able to protect those who are discriminated against under the Americans with Disability Act. Could you just take a moment? I've got 2 minutes left. Could you take a moment and tell us about the issue in the Barber case, and what was your reasoning for permitting a disabled person to sue in federal court for discrimination in that case?
Certainly.
Your case, you're involved in the case. You're in the majority opinion.
Yeah, it was a divided decision.
Right.
The argument was whether Congress had the authority under the spending clause as a condition of the receipt of federal funds that WMATA, the metro here in D.C., receives, that they waive their sovereign immunity to suit under the disability provisions. And the argument was that Congress lacked that authority, that they could not impose a waiver of sovereign immunity as a condition for the receipt of federal funds to allow an individual alleging discrimination on the basis of disability to sue. There was no issue about whether there was sovereign immunity in the absence of a waiver, and the WMATA governing body was opposing the suit on the ground that it had not waived immunity, and they were arguing that Congress lacked the authority to condition the receipt of funds on a waiver of immunity. It was a divided decision, 2-to-1 vote. The dissenter argued that this was an inappropriate exercise of the spending clause power. The majority concluded that no, this was within Congress's authority. It could condition the receipt of federal funds on a waiver of sovereign immunity that allowed an individual alleging that he was discriminated against in employment because of his disability to proceed with the suit. The arguments we rejected were arguments of germaneness. The idea was the funds were for transportation, not for employment, and so that wasn't a germane condition. The majority rejected those arguments. The dissent would have ruled the other way.
But, Judge, thank you very much. Thank you, Mr. Chairman.
Thank you, Senator.
Thank you, Senator DeWine. Senator Feinstein?
Thank you very much.
We're going to take a 15-minute break when Senator Feinstein concludes her questioning at about 4:15.
Thanks very much. Thanks very much, Mr. Chairman. Good afternoon, Judge Roberts. I want to follow up on something that Senator Cole said in his last question, which was sort of asking you to do a look back into some of the things you've written and said. And you've written, and this involves women, either in margin notes or in comments or in memos. And I want to list for you some of the comments and ask you what do you think of them, what do you think of them today. in a memorandum to Fred Fielding, White House counsel under President Reagan, about the nomination of a woman to be recognized for moving from homemaker to lawyer. And your response to nominating this woman for an award was this, quote, "Some might question whether encouraging homemakers to become lawyers contributes to the common good, but I suppose that's for the judges to decide." In a memo responding to a letter from 3 Republican congresswomen that raised concerns about the pay gap that women experience, you said, and I quote, "Their slogan may as well be from each according to his ability to each according to her gender." You also wrote that the congresswomen's concerns, quote, "ignore the factors that explain that apparent disparity, such as seniority, the fact that many women frequently leave the workforce for extended periods of time, etc." In another memo, you implied that it's a canard that women are discriminated against because they receive 59 cents at that time to every $1 earned by men. In a September 26, 1983 memo to Fred Fielding, you rejected an alternative proposed constitutional amendment guaranteeing equal rights to women. In 1982, you wrote a memo to then Attorney General in which you refer to the task force, which was to conduct a government-wide review to determine those laws which discriminate on the basis of gender as the Ladies' Task Force. I mention these examples to highlight what appears to be either a very acerbic pen or else you really thought that way. Did you really think that way? And do you think that way today?
Senator, I have always supported and support today equal rights for women, particularly in the workplace. I was very pleased when I saw, for example, the report of the National Association of Women Lawyers, who went out and talked and interviewed with women lawyers who've worked with me, who've appeared before me. And the conclusion was that I not only always treated women lawyers with respect and equal dignity, but that I had made special accommodations for life-work issues to ensure that women could continue to progress, for example, at my law firm, and had always treated women who appeared before me in a perfectly professional way.
Then why say those things?
Well, let's take the first one you mentioned. It is, to me, obvious in the memo that I've wrote to Fred Fielding that it was about whether or not it's good to have more lawyers, whether they were from homemakers, from plumbers, from artists or truck drivers, had nothing to do with it. The point was, is it good to have more lawyers? That's the way I intended it, and I'm sure that's the way.
And you don't think it was good to have more lawyers?
I think there were probably, the point that Mr. Fielding and I had commented on many occasions was that in many areas there were too many lawyers. And that's a common joke that goes back to Shakespeare, has nothing to do with homemakers. The notion that was my view is totally inconsistent and rebutted by my life. I married a lawyer. I was raised with 3 sisters who work outside the home. I have a daughter for whom I will insist at every turn that she has equal citizenship rights with her brother.
I don't want to belabor it. I'm just trying to understand how you think, because you appear, you speak about modesty and humility, and yet none of these comments are modest or humble.
Well, those comments were in the nature of the tone that was encouraged in our office. It was a small office. They expected we turn projects around very quickly. We were expected to be candid, and if we're making a joke about lawyers, would make for a more enjoyable day on the part of the people in the office. That's what we did.
So it's fair to say you don't think that way. Is that correct?
Well, I don't think in any way that is based on anything other than full equal citizenship rights on the basis of gender. I might tell a lawyer's joke that there are too many lawyers today, but that's all it was back then. On the memo you quoted with respect to the issue of comparable worth, The one thing the memorandum made clear is that the position of the administration was there must be equal pay for equal work. That wasn't the issue in that case. The issue there was whether there should be equal pay for different work and whether judges should determine what type of work was equal.
I'm not arguing that. I'm just arguing what you said, or bringing to your attention what you said then. But I don't want to belabor it. I think you've answered the question. Let me ask you a question on Canarino versus Wilson. This is about the same time in 1982. And you pointed out in answers to prior questions that you were staff and you generally did what people asked you to do. In this case, William Bradford Reynolds, the top attorney in the Civil Rights Division, indicated that there had been substantial, he thought, discrimination in prisons in Kentucky, and that the Justice Department had done an investigation. And they found that male prisoners were given training for higher paid jobs, for a greater variety of jobs, and were given training for longer periods of time. Your memo contradicted his recommendation to intervene. Why would that be if you just follow the policy of the office?
My understanding there was that there was a question whether the intervention in that case, the case was being pursued by private litigants already, question whether intervention by the federal government in that case was consistent with the Attorney General's approach to institutional litigation. That was an approach that he had laid out in several speeches, memoranda, and as a staff member, it was my job to call to his attention areas where I thought there may be inconsistencies in areas where he wanted to set policy priorities.
In response to the chairman's question this morning about the right to privacy, you answered that you believe that there is an implied right to privacy in the Constitution, that it's been there for some 80 years, and that a number of provisions in the Constitution support this right, and you enumerated them this morning. Do you then believe that this implied right of privacy applies to the beginning of life and the end of life?
Well, Senator, first of all, I don't necessarily regard it as an implied right. It is the part of the liberty that is protected under the Due Process Clause. That liberty is enumerated, yes. And the exact scope of it with respect to the beginning of life and the end of life, those are issues that are coming before the court in both respects. And I don't think I should go further to elaborate upon whether or not it applies in those particular situations. Obviously, it has been articulated by the court in both contexts, the Cruzan case with respect to the end of life, the Glucksberg case following Cruzan, but I don't think it's appropriate for me, given the fact that cases arise on both of those questions, to go further.
All right, let's move right along. This morning, there was a discussion about stare decisis, and you pointed out that there were factors in a consideration of stare decisis. And I think one of the things you said was workability of framework is one of the main principles you look for in stare decisis. Well, in its decision in Casey, the court specifically affirmed the doctrine of stare decisis as it applies to Roe. The court reviewed prudential and pragmatic considerations to gauge the respective costs of reaffirming and overruling a case, that case. In doing so, the court unambiguously concluded that Roe has in no sense proven unworkable. Do you agree with this conclusion?
Well, that determination in Casey becomes one of the precedents of the court, entitled to respect like any other precedent of the court under principles of stare decisis. I have tried to draw the line about not agreeing or disagreeing with particular rulings, but that is a precedent of the court. It is a precedent on precedent. In other words, it is examined Roe.
So you agree that the court said that, obviously?
Well, it said that, and that is a precedent entitled to respect under principles of stare decisis like any other precedent of the court. But in terms of a separate determination on my part whether this decision is correct or that decision is correct, my review of what other nominees have done is that that's where they draw the line, and that's where I've drawn the line.
So, workability is clearly one thing. Is another one reliance?
Certainly, or as it's often expressed in the court's opinions, the settled expectations. People expect that the law is going to be what the court has told them the law is going to be, and that's an important consideration.
And in Casey, again, the court stated, and I quote, "The ability of women to participate equally in the economic and social life of the nation has been facilitated by their ability to control their reproductive lives." And that this ability to control their reproductive lives was enough of a reliance to sustain Roe. Correct?
That's what the court concluded. I think you're reading from the plurality of the joint opinion.
That's correct.
Of Casey. Yes.
That's correct. Now, unlike my experience, there are now entire generations of women who know a world only where their reproductive rights are protected. Do you agree with the court that this reliance is sufficient?
Well, again, I think that's asking me whether I think the decision was correct or not on that point. It certainly was the analysis of the joint opinion in the court, entitled to respect as precedent like any other decision of the court under principles of stare decisis. And that would certainly be where I would begin if any of these issues come before the court. If I were to be confirmed, I would begin with the precedent that the court has laid out in this area.
One other question on Casey, and I'd like to quote from something that Justice Ginsburg said in the transcript in her confirmation hearing in a discussion with then Senator Brown. The Casey majority understood that marriage and family life is not always what we might wish them to be. There are women whose physical safety, even their lives, would be endangered if the law required them to notify their partner. And Casey, which in other respects has been greeted in some quarters with great distress, answered a significant question, one left open in Roe. Casey held a state could not require notification to the husband. Do you agree?
That is what Casey held, yes. And that's, as I said before, a precedent of the court, like any other precedent of the court, entitled to respect under principles of stare decisis.
Thank you. One other reading from Justice Ginsburg's testimony. Abortion prohibition by the state, however, controls women and denies them full autonomy and full equality with men. That was the idea I tried to express in the lecture to which you referred. The two strands, equality and autonomy, both figure in the full portrayal. Do you agree or disagree?
Well, I think then Judge Ginsburg felt at greater liberty to discuss that precisely for the reason you noted, that she'd given a lecture on the subject. Those are issues that come up again and again before the court, and consistent with what I understand the approach to have been of other nominees, I don't think I should express a view on that.
I'd like to move on. In Bray, you argued on behalf of the government as Deputy Solicitor General that the right to have an abortion is not specific to one gender. Specifically, your brief stated, quote, "Unlike the condition of being pregnant, the right to have an abortion is not a fact that is specific to one gender," end quote. In your oral argument, you went on to make this point by comparing Operation Rescue's attempts to prevent a woman from exercising her privacy right to make decisions about her pregnancy to an ecologist's efforts to block an Indian tribe from using their exclusive fishing rights. Do you think that's an appropriate analogy?
Well, Senator, it was a position and an argument that the administration made that was accepted by the Supreme Court by a vote of 6-3. The underlying point was that under the statute at issue in Bray, the Ku Klux Klan Act, required under the Supreme Court's precedents that people engaged in the challenged activity must be motivated by a discriminatory animus. obviously under the Ku Klux Klan Act, the classic case, racial hostility. And the issue was, are people opposed, in the Bray case, opposed to abortion, opposed to women? And the determination of the court was that no, that there are people who are opposed to abortion, and that does not constitute opposition or discriminatory animus against women, and therefore that the Ku Klux Klan Act didn't apply. Many other provisions obviously apply in a case of abortion protester violence, including state law and other provisions of federal law. But the Supreme Court concluded 6-3 that there's no discriminatory animus based on opposition to abortion.
Thank you. I'd like to move to another subject because my time is moving on. And that's what's been happening in the court in the last 10 years. As I mentioned, for 60 years, the court didn't strike down a single federal law for exceeding congressional power under the Commerce Clause. Yet, in the last decade, the court's reinterpretation of the Commerce Clause has been used to strike down more than 36 cases. The court's future decisions will determine whether the Congress will be able to take necessary action to stop child pornography, combat violent crime, ensure child support payments, prevent discrimination, improve our schools, and protect our environment. My question is, do you agree with the direction in which the Supreme Court has moved in more narrowly interpreting congressional authority to enact laws under the Commerce Clause?
Well, of course, I've tried to avoid saying whether I agree or disagree with particular cases, but I would point out in this area in particular, I think it's very important to look at the most recent case, which is the Raich case, the medical marijuana case, because the argument there was that these two decisions that you're talking about that were the first in the 60 years, Lopez and Morrison, the argument there was based on Lopez and Morrison, Congress lacks the power in this area. And what the Supreme Court said in the Raich case, which I think is very important, it said there are a lot more precedents on the Commerce Clause besides Lopez and Morrison. And the appropriate way to regard those is two decisions in a more than 200-year sweep of decisions in which the Supreme Court has given extremely broad, it's recognized extremely broad authority on Congress's part, going all the way back to Gibbons versus Ogden and Chief Justice John Marshall, when those Commerce Clause decisions were important in binding the nation together as a single commercial unit. So, without commenting on whether particular decisions are correct or not, I do think it's important to recognize that the Court itself, in its most recent decision, has said you need to focus on the broad sweep and not just on those two decisions.
Let me move to the case of the hapless toad, known more commonly as Rancho Viejo versus Norton. Do you believe there's a basis for sustaining the Endangered Species Act other than the Commerce Clause?
Well, what the opinion I wrote in there noted that the panel decision that I thought should be reheard en banc looked at one ground for under the Commerce Clause, and the concluding paragraph, in my opinion, said that we ought to rehear the case to look at other grounds that were also under the Commerce Clause, but they were not the particular prong of the Commerce Clause analysis that the panel opinion had relied on. And the reason was that, as I explained in the opinion, another circuit court had suggested pointedly that the approach in the panel opinion was inconsistent with the Supreme Court. And I thought if there was another basis for sustaining the Endangered Species Act that was not inconsistent in the view of another circuit court, that we ought to look at that and try to do it. It really reflects a restrained and minimalist approach. If there's a ground that doesn't cause another circuit court to say you're violating the Supreme Court precedents, we ought to look at that and see if we can rest
That's the point I'm trying to get at, is you're saying that the fact that the toad was almost only found in California means that it was an impermissible use of the Endangered Species Act. Well, then that raises a question. What if the toad strays across the border? Or what if the toad, this is the last remaining toad?
Right. But the One point I would emphasize is my opinion did not conclude that there was no authority under the Commerce Clause in just that situation. There was another dissenting opinion that was filed by another judge who said this violates the Commerce Clause. I did not join that opinion. I wrote separately to say that we should hear this en banc with all the judges because there are other ways of sustaining this act that don't implicate the concern that has caused the other circuit to question our approach, that had caused the dissenting judge to conclude there was no authority. And I thought we ought to look at those other grounds, because if we could sustain it without implicating that objection, that would be better all around. I did not take the position that it was outside the scope of the Commerce Clause. It was a question of which ground under the Commerce Clause we ought to look at.
Because there's a great deal of concern as to what this then means for the implication for all environmental law, the Clean Water Act, the Clean Air Act. But if I understand you correctly, what you're saying is that you do not believe that the Commerce Clause should prohibit legislation in this area. Is that correct?
I have not had occasion to decide that. I did not decide it in the Rancho Viejo case. One of the other judges did, and I did not join that opinion. What I said is we should consider these other grounds. Now, I didn't have the opportunity, because there was a dissent from rehearing, to consider those other grounds. Those other grounds were what other courts, the Fifth Circuit in the GDF case, had used to sustain application of the Endangered Species Act in the cases that came before them. They didn't get into the question of whether you look at the regulated activity, the building, or the actual what was prohibited, the taking of the toad. They analyzed the protection of the endangered species as implicating a commercial activity. And that allowed them to sustain the act without regard to whether it had an interstate effect itself.
Thank you very much. I'd like to ask a question or two on church and state. You know, I mentioned in my opening statement that for centuries people have been persecuted for their religious beliefs, and our country grows more diverse every day, and tensions among different beliefs have grown. I really believe that there's a brilliance in what the Founding Fathers did in drafting the First Amendment and how it protected an individual's right to practice their belief, whatever it may be, but also protect against using religion against individuals by prohibiting the government from becoming and or imposing religion. In 1960, there was much debate about President John F. Kennedy's faith and what role Catholicism would play in his administration. At that time, he pledged to address the issues of conscience out of a focus on the national interest, not out of adherence to the dictates of one's religion. And he even said, "I believe in an America where the separation of church and state is absolute." My question is, do you?
Senator, I think the reason we have the two clauses in the Constitution and the First Amendment reflects the framers' experience. Many of them, or their immediate ancestors, were fleeing religious persecution. They were fleeing established churches. And it makes perfect sense to put those two provisions together: no establishment of religion and guaranteeing free exercise. That reflected the framers' experience.
You can't answer my question, yes or no?
Well, I don't know what you mean by absolute separation of church and state. For example, recently in the Ten Commandments case, the court upheld a monument on the Texas Capitol grounds that had the Ten Commandments in it. They struck down the posting of the Ten Commandments in a Kentucky courthouse. Is it correct to call the monument on the Texas Capitol grounds with the Ten Commandments, is that an absolute separation, or is that an accommodation of a particular monument along with others that 5 of the justices found was consistent with the First Amendment? So I don't know what that means when you say absolute separation. I do know this, that my faith and my religious beliefs do not play a role in judging. When it comes to judging, I look to the law books and always have. I don't look to the Bible or any other religious source.
It has been reported that during your meeting with Senator Wyden, while discussing end-of-life issues, you cited the dissent of Justice Brandeis in Olmstead. I'd like to quote from it. The makers of our Constitution undertook to secure conditions favorable to the pursuit of happiness. They recognized the significance of man's spiritual nature, of his feelings, and of his intellect. They knew that only a part of the pain, pleasure, and satisfactions of life are to be found in material things. They sought to protect Americans in their beliefs, their thoughts, their emotions, and their sensations. They conferred, as against the government, the right to be left alone, the most comprehensive of rights, and the right most valued by civilized men. To protect that right, every unjustifiable intrusion by the government upon the privacy of the individual, whatever the means employed, must be deemed a violation of the Fourth Amendment. Do you agree with Justice Brandeis?
I agree with his expression that it's a basic right to be left alone. I think that animating principle is a very important one. With regard to particular restrictions, he was talking about wiretapping, or I forget how the interception actually at issue there. I don't think it's appropriate to comment on. But as a general statement of the principle, and it reflects just a basic understanding that it's a free country, and the right to be left alone is one of our basic rights. I do agree with that.
I do think the implication of what you said to Senator Wyden, and I've discussed this with him, was that one has the right to make their end-of-life decision.
Well, that's an issue that is before the court in particular cases, and I can't comment on a case that's coming before the court. If I am confirmed, I would have to confront that case with an open mind in light of the arguments presented, in light of the precedents of the court, and the litigants in those cases are entitled to have judges that haven't expressed views on that particular case.
Well, let me ask you this question then. In an interview on PBS after the court ruled in Washington v. Glucksberg, a case involving a state statute that banned assisted suicide, you said, "I think it's important not to have too narrow a view of protecting personal rights." What did you mean by that?
Well, I went on to explain that the right, anytime there's an assertion of a right, there's quite often an assertion of a contrary right. I think it was similar to the point Senator Kyle was making earlier, that, for example, if you're asserting a right against government regulation, then the right of the people to regulate through their elected representatives that's being struck down, that right is being restricted. So it's usually not, it's often not, we can view that there's a right on one side and there's nothing on the other side. There's often an assertion of a right on the other side, and what the courts have to do is make sure they provide a level playing field in which people disputing the impact of the Constitution on whose right prevails have judges who will decide that case according to the rule of law and not according to whether they think one right should prevail or another.
But do you believe then that the federal court should become involved in end-of-life decisions?
Well, Senator, that is exactly one of the questions that's before the court, and I can't answer that in the abstract. I have to answer that on the basis of the parties' arguments, on the basis of the record in the case, and the basis of the precedents. An abstract opinion that would prejudge that case would be inappropriate for a nominee to express.
Let me ask it another way. Do you believe that the courts should have a limited role in that situation?
I think courts have a limited role in general, and that is that they only interpret the law. They don't make the law. They don't shape the policy. Now, the application of that basic principle, which is very important to me, in a particular case, is obviously something that has to wait for the litigation of that case, the arguments in that case, the arguments of the lawyers about whether it's consistent with the precedents or inconsistent with the precedents. But the basic principle that courts should not be shaping public policy, that's for the legislators, is a fundamental principle with which I agree.
Thank you, Mr. Chairman. Thank you.
Thank you, Senator.
Thank you, Senator Feinstein. Since I announced the break at 4:15, I've been advised that there was a vote at 4:30. So Senator Sessions has graciously agreed to split his 30-minute round, 15 minutes, and then we'll go vote. So we'll now turn to Senator Sessions for 15 minutes, and we'll break at that time and take a 15-minute break to go vote.
Thank you very much, Mr. Chairman. I guess this microphone is working. Judge Roberts, I want to congratulate you on your excellent testimony. You have validated the President's confidence in you. Many people said President Bush obviously looked around and finally decided to choose the best. And I think you've proven that correctly. The ABA has rated you unanimously. American Bar Association, in their formal rating process, unanimously rated you well qualified, the highest possible rating that they give. And they have quite a number of lawyers that vote on that, so to get a unanimous vote is not that frequent. And for a higher office, they have a higher standard. And I think that's particularly worthwhile that you receive that recognition. I note that some of our legal professional journals have given you remarkable accolades. The American Lawyer in 2004 wrote that you were, quote, one of the Supreme Court's finest practitioners. And the Legal Times said, quote, you are one of the top appellate lawyers of your generation. And the Legal Times also said that you are, quote, viewed by many as the best Supreme Court advocate in private law firm practice. Those are high praise, and I think today we've seen why people would think that of you. I also would offer for the record, Mr. Chairman, a letter from former Democratic Attorney General Bill Baxley from Alabama. He prosecuted the first prosecution of the church bombing cases in Birmingham successfully. He is a lifelong Democrat, as he notes, an elected member of the State Democratic Executive Committee.
Without objection, we made a part of the record.
He said this, Senator, I know Judge Roberts well. I have entrusted 3 important appellate matters to him. In each instance, I met with him and engaged him in extensive conversation upon a wide range of topics. Because he is a man of such remarkable intellectual brilliance, I sought him out upon private as well as professional topics, enjoyed more than one meal with him, and was, each time, overwhelmed not only by his intelligence, but also his innate sense of fairness, by his sensitivity to every aspect and angle of consideration of every issue addressed by him, and by his somber sense of decency and justice. A somber sense of decency and justice. I think a pretty good phrase. My love of my country surpasses politics, Mr. Baxley says. It compels me to support Judge Roberts in every possible way in order that justice might most effectively prevail in the United States Supreme Court. I am confident in the ability of Judge Roberts to fairly and without any agenda of any kind address each legal issue which comes before him. I am equally confident of his ability to lead the Supreme Court in an administrative capacity. I have no doubt that the diverse opinions of each Associate Justice sitting on the United States Supreme Court will receive greater deference and consideration under his leadership than under any other Chief Justice with whom they have ever served. This wise and circumspect man deserves this office. So I think we have seen a great bipartisan recognition of your capabilities, and the respect that you have reaches broadly. I also would recall Judge Roberts said in my opening statement, I suggested that the pattern around here is to take out old statements and memorandum and bring them up out of context, and that particularly the outside groups and sometimes senators would get confused, or sometimes these groups, I think, deliberately have attempted to paint a picture of you or the positions you took that are not fair or accurate. I would just want to go over a few of the cases and to deal with some of the issues that you have already been questioned with to make sure that we're square about it. On the Gwinnett case, the Title IX, the women's education case, the position you took that would deny the right to sue a state entity, a government entity, for money damages, wasn't that a position consistent with the position of the Court of Appeals that had written the opinion, the only opinion on that subject?
Yes,
So
that was the Court of Appeals position.
Yeah, so you, in advocating that position, were expressing a view that was the view of the highest federal court in the land at that time.
Yes.
With the question to the Grove City case, it was good that Senator Grassley from Iowa, I knew about that, and I think he clarified that question well here. With regard to Bolden versus City of Mobile, you and Senator Kennedy had an exchange. Well, I'm from Mobile. I was not involved in the litigation, but know something about that litigation. And when the exchange ended, as I recall, Senator Kennedy was insisting that the Zimmer case was the established law, and that a number of cases had said that effects test applied, whereas you were contending that at the time you took the position you did, that the Supreme Court had ruled that it was an intent standard was required, and that Bolden set the decision on that. And I guess the question for us today, who was right? You or Senator Kennedy?
Well,
I didn't want to ask you, but go ahead.
No, I don't know if
I say the senators returned.
It was a renewal of a debate that was had between the administration and Senator Kennedy 20-plus years ago, and certainly the issue of whether the Supreme Court had interpreted Section 2 and what it had said and whether or not it was correct was mooted. Senator Kennedy's position eventually prevailed as a matter of legislation through the good offices of Senator Dole and others. The compromise was worked out, and the totality of the circumstances test enacted under Section 2.
Now, but the truth is it not, that Bolden versus City of Mobile had been decided by the Supreme Court, and the Bolden versus City of Mobile said that you had to show when you consider a form of a local government, that before you could throw it out, create a new government for that city, you had to show that it was designed in a way to intentionally deny equal rights to the minority citizens.
That was my understanding of, and certainly the administration's understanding of Mobile and its interpretation of Section 2. And as I said, the debate was largely mooted by the legislative change that was enacted.
I'm just trying to get this thing straight, because I don't want anybody to be misinterpreted. Bolden versus City of Mobile quoted Zimmer. It was the final word on the matter, and it ruled that before the federal government could throw out a government of a city and require a new government to be established, there had to be an intent to discriminate. And that was consistent with the Voting Rights Act. And then when the Voting Rights Act came up for reauthorization, the legislature, the Congress, passed a law and changed the law that in effect said the effects test. If it had the effect of discriminating or keeping African American citizens from being elected to office, that could justify the removal of the existing form of government and establishing a new government.
Well, that's right, and it's in many areas, well, certainly every area involving an interpretation of the statute. The final say is not with the Supreme Court. The final say on a statute is with Congress, and if they don't like the Supreme Court's interpretation of it, they can change it, and that's what happened in this case.
Well, the Voting Rights Act, let me say, is a tremendously critical historical event. It's transformed the South. I think Senator Kennedy or others said that grandchildren and children today are being able to vote and because of this right, and that's true. Not only are they being able to vote, they're being able to be judges who supervise elections, sheriffs, mayors, city councilmen, county commissioners. Alabama has more elected African-American office holders than any other state in America, and we're proud of that. And, but this was a powerful act, and it did change the makeup of county commissions, city commissions, statewide boards, all over Alabama, all over America. And it was a big step, but the Congress made that, and you were correct when you said that your position was consistent with what the Supreme Court ruled at that time. With regard to the question of comparable worth, I think Senator Feinstein was clear about this, but I'd like to make it a little bit clearer. You have consistently favored equal pay for equal work, have you not? And did not President Reagan also favor that explicitly
Absolutely.
and openly? It's the question of this comparable worth theory that apparently one district court found in favor of, but that every circuit court and every other court that considered it rejected it, that said that some body, some commission, I guess, would decide whether a secretary should be paid as much as a truck driver, or and make those kind of value judgments decisions. Isn't that the difference between
That's
those
right.
two aspects?
Yeah, there's no question of equal pay for equal work. It's the idea that someone should decide that different jobs are of comparable worth and that therefore they should be paid the same. And the district court adopted that approach. It was reversed by the Ninth Circuit Court of Appeals in an opinion by then Judge Anthony Kennedy.
Well, that's right. I know he did right on that, and I think that the 6th, 7th, 10th, and 9th circuits all rejected that idea, and frankly, it hadn't been heard from since. I'm glad that you and President Reagan didn't agree to that. At the time, we would have commissions of incredible complexity trying to decide very important matters. The National Academy of Sciences, in fact, found that and declared it did not believe that the value or worth of jobs could be determined by fair and scientific methods. So I think that's important. Judge Roberts, I tried a lot of cases in federal district court. I've written appeals to the federal appellate courts and argued a few times in the Court of Appeals. I'd like for you to help explain to us how this court system works and what an appellate judge does. I mean, the appellate judges don't go about to set policy in America. They don't go out to supervise and superintend the legislative and executive branches. They decide cases that come before them. So, isn't it true that normally a case would be initiated in a federal district court or a state trial court, and a trial would be held, often with a jury, and a judgment is rendered?
Yeah, and that's what most of us think of when we think of going to court. You're there, you bring in the witnesses, they testify, they're cross-examined by the other side. There's one judge supervising the trial. If it's a jury case, the jury is there, and that's where most of the fact-finding takes place. People have different versions of events, who was there, what did they do, and people tell different stories, and that's where you try to sort that out, either before the jury or the single judge.
And a judge has to rule. He has to rule on evidentiary matters or legal matters, and sometimes the judge is in the midst of trial, and maybe he makes an error, maybe he doesn't make an error. But every word of that trial is put down. It's recorded. And so after the trial, if the losing party is unhappy, they can take an appeal.
That's right.
And when they do that, it goes to the Federal Court of Appeal for that circuit. And they point out to the Court of Appeals where they think the judge made an error. And they say this was wrong and we want a new trial judge or remediator or some other remedy. And isn't that what happens in the next step?
And the big difference when you get up to the Court of Appeals is that the facts are not really in play anymore. Somebody's been determined, they think you're guilty, or they buy your version of the events. The Court of Appeals usually just looks at the legal issue. Somebody says the judge made a mistake. He shouldn't have let that witness testify, or he should have recognized that the police had no authority to conduct that search in a criminal case. And that's appealed to the Court of Appeals, where in the federal system, there are 3 judges, and they're just looking at that legal question. And they just go back and look at the law, the precedents, and determine whether or not the law was correctly applied in the trial court, or if a mistake had been made and they need to do it over again.
And if they appeal, the lawyers write sometimes beautiful, carefully written briefs that point out the reasons why they think an error may or may not have occurred. Isn't that correct?
As a Court of Appeals judge, that's exactly the kind of brief you're looking for, and every now and then you get one.
And sometimes when you read the first brief, you're persuaded, and when you read the second brief, you think maybe you weren't so... Maybe it wasn't as clear as you thought it was when you read the first one.
Not just sometimes, Senator. Quite often, that's my reaction. That's part of the adversary system, and you need to have lawyers doing a good job presenting the best arguments on either side, so you can feel comfortable that you're making as good a decision as you can.
And so, as the lawyers in the case and the clients and the parties want a judge who will carefully read those briefs and be fair and careful in analyzing whether or not they got a fair trial to ensure justice took place.
That's what I was always looking for when I was a lawyer, Senator, yes.
Mr. Chairman, I see this clock is going around in circles down here, I think. What do you want to do about time?
Well, they haven't started the vote, and we all know that that's not totally predictable even when they say 4:30. Would you care to continue until the vote starts?
I would be pleased if that would, the chairman
Fine.
would. So is that, you know what my time is now?
Yeah, you can run the red to. Well, it just went off.
This is like a football referee. Put so much time back on the clock. It says a minute left.
The red just started there, and you can run the red till 7 minutes and 30 seconds.
All right, very good. Who am I to disagree with that chairman? What was that?
Senator Sessions, if you would...
I'll have 15 minutes after this.
You have 15 minutes left, yes. Start the clock back at 15 minutes.
Okay, good. Thank you. The doctor down here is good at mathematics. Businessman, too. And now... But it's even more complicated in that, in doing justice. And on the Supreme Court, if a case comes up to you, you'll probably have briefs from both parties. You'll receive the transcript of the trial that the issue arises from, and you'll study that. And you have several law clerks who will help you study that. And every one of the 9 Supreme Court justices are also studying this same record and all these briefs. And isn't it true that friends of the court can submit briefs?
Well, at the Supreme Court level, that's very common. And in some cases, there are quite literally hundreds of so-called friends of the court or amicus briefs. Different organizations that are interested in the particular ruling and have a particular perspective. A few of them are even helpful.
And so you review that, and then you frequently set the case, or normally set the case for oral argument.
If the Supreme Court decides to, this is of course a very big part of their function. They get some 10,000 petitions every year for people saying, I want you to hear my case. You know, all lawyers say they're going to take it all the way to the Supreme Court. 10,000 people try to do that every year. These days, the court hears about 80 of those, 80 of those 10,000. And the selection of which 80 to take is obviously a big part of the court's function. But once they've selected those 80 cases, then they go in and have new briefs on the merits, and all these amicus briefs are filed from different organizations presenting their arguments or their particular perspective, and then it's set for argument.
So the lawyers from both sides then appear before they're in court over in the Supreme Court building, and they answer questions and make their presentations as to why they think the court should rule the way they would like it to.
They usually get an hour for the whole case, so each side gets a half hour, and that half hour is taken up almost entirely by the justices' questions. I went back once and counted the questions during my half hour, and there were over 100 questions. Obviously, some of them the rapid-fire questions, and if you follow the court, you could probably guess who was asking those, and others are more elaborate questions, but more than 100.5 hours. So the job of the lawyer there is to be totally prepared to answer all of those questions. And of course, some of them are going to lead into traps, and you have to be careful about that. Others are going to be the very difficult questions that the court is eventually going to base its decision on. But it's a very both exhilarating and demanding process to go through an oral argument before the Supreme Court.
And I think there's little doubt that you are the best practitioner of it in the country. But with regard to that, you then finish, and do the judges then meet in conference to discuss the case?
They do. The justices, each of whom has prepared the case by not only reading all these briefs and attending the argument, talking it over with their law clerks, but also reading back over the cases, the precedents that the lawyers have been arguing about. They go back and look at those. And then just the justices in the conference room. No clerks, no staff, just the 9 justices. Sit in the conference room and talk about it, thrash out the case, eventually get to a point where they take a vote on what they think the disposition should be. The decision should either be affirmed or reversed, or sometimes something else in between, half affirmed, half reversed, sent back, whatever. And then the opinion is assigned, and that's still very much part of the process, the writing of the opinion, because quite often, or maybe not quite often, but often enough, the justices find out that as they try to write a particular opinion, different problems come up. It doesn't seem as, it's not writing as they thought it would, and sometimes they have to go back and revisit the case because the justice assigned the opinion decides that it's not, should come out the other way, or there should be a different reason, a different basis for the decision. And then once the justice who's writing it is comfortable with the opinion, they send it around to all the other chambers, and the individual justices, if they agree with it, they send a memo around to everybody else that says, please join me. That's just the jargon the justices use. It means please join my name to your opinion. And sometimes they'll have suggestions. You know, I'd be happy to join your opinion, but I disagree with this section, or I disagree with this footnote, or I disagree with this line of reasoning. If you could change that, I'd be able to join. Well, if you're a justice who's getting, this is the first reaction you've gotten, the first vote back, you might be a little more willing to make a change to accommodate that suggestion. If you've got 7 votes already in the bank and somebody says, please change this or change that, maybe you're a little less willing, because maybe then some of the others say, well, now I'm not happy with that change. And it can obviously get to be a very complicated process as the memos fly back and forth and the court tries to come to some consensus around an opinion. Often, maybe too often, there's not total agreement, and somebody will write a dissent and send that around, and others will join that. Concurrence, you know, I can't agree with your reason, but I agree with the result. And so I'm writing separately to give you my reasons. And the balance changes. Somebody can write a concurrence, and all of a sudden they've got 5 votes, and it's the majority. And the other majority, the original majority, becomes the concurrence. But it's the analysis is done at, and this has been my experience on the Court of Appeals as well, a very high level. And I think it's critically important that it's just the justices alone who go into the conference room. Just as on my court now, it's just the judges who go into their conference room. Because judges and justices in that situation can be a lot more open with their views. And it's been quite common in my experience over the past more than 2 years to have a judge say, you know, this is how I view the case. And then another judge say, well, what about this? And the judge can say, well, I hadn't thought about that. Or the record says this, and you get out the record. Put it out there and look at it.
But at some point, you agree to sign on an opinion, one way or the other.
Right.
And that becomes a decision of the judge and maybe the majority of the court, or maybe a dissent. But that's a decision that's made. Isn't that why you should not, in this hearing today, blithely start expressing opinions on complex matters when you haven't been through that process, and start prejudging matters before you've read the briefs, before you've read the transcript, before you've heard the arguments, before you've talked to your clerks, before you've discussed it with other judges? Isn't that the essence of what justice is this careful process that leads us to as fair a result as humanly possible.
Well, I think that's perfectly accurate. And if you've had the experience, as I know every judge and every justice has, of having your original view changed when you read either the other side's brief in a case after reading the opening brief, or had your view changed as a result of the discussion at conference, or had your view changed when you tried to write the opinion one way and it came out the other way, then you appreciate the significance of that process. And it's a total distortion and a perversion of that process to start out by saying, well, you know, I testified under oath that I thought this decision was correct, so I'm done. You know, no need to read the briefs, no need to listen to the arguments, no need to go into conference and talk with the other judges on the bench. I've already given my view under oath. Or even if you are going to be open to reconsideration, to start with that barrier. I testified under oath that this is the correct approach, that this is the right result. Now maybe you can persuade me otherwise. Well, that's not the burden that the litigant should have to take. The litigant should be able to know that all of the judges, all of the justices that person is arguing before have an open mind and are fully open to the process.
You wouldn't want to call Senator Biden and ask him permission to change the commitment you made, would you, in that hearing?
No.
Just a joke there a little bit. You don't want to have to read the transcript of this hearing by the time when you try to decide how to rule on the case to make sure you didn't make some commitment. Well, I mean, I think that's all I wanted to point I would like to make there. You know, Senator Specter came right out the chute asking you about stare decisis and Roe and other related type matters, and that's an important question. As I understand it, you committed to Senator Specter that you would bring no hidden agendas to this matter, that you would consider any case that came up under Roe or any other case that might impact stare decisis, and that you would apply a reasonable professional analysis to that, drawing on the history of courts and their opinions in dealing with these cases, and would try to make a fair and honest and objective decision. Is that what I understood you to say?
That's what I understood my testimony to be, yes.
And you're not saying one way or the other how you would rule on Roe or some of the other cases that have been...
No, I feel that it would be very inappropriate for me as a nominee to tell how I would rule on a particular case that might come before the court.
Well, I would like to know how you'd rule on a lot of those cases too, but I didn't ask you when you came and talked with me, and I don't think it's appropriate. I don't think those of us who are politically conservative ought to look to the courts to promote our conservative agenda through the manipulation of interpreting words of the Constitution or statutes. I don't think liberals have a right to ask the court to promote their agenda by twisting the plain meaning of words to accomplish an agenda. What we need is what you said, an umpire, fair and objective, that calls it like they see it, based on the discrete case that comes before the judge. I think that's most important. And I would just say, I don't know the answer to those questions legally and how it'll all come out, but I would just offer that polling data continues to show that young people and numbers in general are showing that the people are more hostile to abortion than they used to be. Perhaps it's seeing the sonograms and those kind of things. They 75%, according to a Harris survey, said that they didn't think an abortion was proper in the second trimester. 85% said they didn't think it was proper in the last trimester. I just saw an interesting article by Mr. Benjamin Wittes. He writes for the Washington Post. He declares he's pro-choice and says, let go of Roe. And he goes into an analysis of it. He said, I'm not necessarily thinking Roe ought to legally be overturned, but if it does die, I won't attend its funeral, nor would I lift a finger to prevent a conservative president from nominating a justice who might bury it once and for all. This was in Atlantic Monthly, January of this year. And he goes on to say, Roe puts liberals in the position of defending a lousy opinion. that disenfranchise millions of conservatives on an issue about which they care deeply, while freeing those conservatives from any obligation to articulate a responsible policy that might command majority support. And he goes on, and as have others. He goes on to say this, the right to an abortion remains a highly debatable position, both jurisprudentially and morally. He also noted that in the years since the decision, an enormous body of academic literature has tried to put the right to an abortion on firmer legal ground, but thousands of pages of scholarship notwithstanding, the right to abortion remains a constitutionally shaky proposition. Abortion policy is a question that the Constitution, even broadly construed, cannot convincingly be read to resolve. So that's one opinion. I'm just saying you will have to deal with it, and I just don't think that we ought to take the view that that matter is open and shut, and I hope that we'll take you at your word that your mind is open and you will evaluate the matter fairly according to the high standards of justice that you can bring to bear to that issue and any others like it that come up. Will you give us that commitment?
Absolutely, Senator. I would confront issues in this area as any other area with an open mind in light of the arguments, in light of the record, after careful consideration of the views of my colleagues on the bench, and I would confront these questions just as I would any others that come before the court.
Well, I'm of the view that the Constitution is a contract with the American people, that developments will occur that clearly fit within the ambit of a fair reading of that Constitution that were never contemplated by the founders. Things do change, and we have to apply new circumstances. But wouldn't you agree a judge should never make an opinion that is beyond what a fair interpretation of the Constitution would call for?
Yes.
Judge Roberts, thank you for responding to my questions and to those of the other members of this body. You've been open, honest, and direct in providing a great view of your judicial philosophy and how you approach cases. I appreciate the fact you have correctly avoided some questions. Some you should not answer. You hadn't read the briefs and heard the arguments and thought about it. But you've carefully answered the appropriate questions, and we respect you for it. Thank you.
Thank you, Senator Sessions. The vote is now in process. We will recess until 5:05, at which point we'll call on Senator Feingold for his 30 minutes of questioning. We stand in recess.
Y'all been here for a while, so you're welcome to hurry. Julie, you cannot come back. Yeah, but we'll probably pull you out
On the left side of your screen is former RNC Committee Chairman, former Republican National Committee Chairman Ed Gillespie talking to Judiciary Committee Chairman Arlen Specter. So a 15-minute break here in the second day of hearings for the Chief Justice nominee, John Roberts. The committee will be back at 5:05 p.m. Eastern Time, and we will show it here on C-SPAN and on C-SPAN 3. It's also being simulcast on C-SPAN Radio and cspan.org. Now, more from the first round of questions from committee members coming up after the break. We'll hear from Democrat Russ Feingold of Wisconsin, then Republican Lindsey Graham of South Carolina, and New York Democrat Charles Schumer. Members are heading to the Senate floor for a vote. They're dealing on the floor with an appropriations measure, one of the yearly bills that come to the floor and funds the federal government, dealing with the Departments of Commerce, Justice, and also science appropriations. A vote dealing with law enforcement programs in areas affected by Hurricane Katrina. So if you want to watch that, you can check out C-SPAN 2. Senators in this first round get 30 minutes of questions each, and we're hearing that they will end for the day at 6:30 p.m. Eastern, and then return tomorrow for final day of questions for this nominee. The committee hopes to have the end of the hearings by the end of the week, and they'll take a vote in committee next week and send it to the Senate floor the following week. Reminder that we will be showing the second day of this confirmation hearing in its entirety tonight. Expected to show it on C-SPAN 2 at 9 p.m. Eastern Time. And pictures here of some of the media talking with some of the staffers who are in back of the senator's table. We wanted to find out a bit more about what those staffers do, so we recently spoke with one of them.